impeachment. The only punishment, if you will, is removal from office. And in 3 unusual impeachment cases in the history of all 19 impeachment cases in this country, all of which are covered in the book, in all 19 cases, only three of which involved a second penalty. The Senate is allowed to vote and forever bar that office holder from holding future federal office. That's it. If you're gonna want to put someone in prison, then you criminally indict them. And let's say this president, and there's a debate whether you can do it while he's in office. Let's say we indict and convict President Trump of some wrong. And let's say after the appeals he goes to jail while he's president. Then he'll reign from jail, folks. There's nothing about the criminal system. There is no crime he can commit that he'll be convicted of that will prevent him from continuing to be president of the United States. And that concept is completely unknown to almost everyone to whom I speak who hasn't read a book about it. Let me repeat, and this is why I'm going around the country really, to try to tell people that when you hear all these pundits and even some congressmen talk about it, if you convict the President of the United States of a crime and he goes to jail, he'll rule from jail. The only way to remove a president due to the harm he's causing us, that's the main criteria for impeachment. Is he capable of causing substantial harm to the United States? The only way to do it, other than the 25th Amendment, which has never been tested, which will go on appeal and is very difficult, more difficult than impeachment, because ultimately it will require 2/3 of both the House and the Senate. The only way to do it is impeachment. The only way to do it is impeachment. And we have 19 cases to go by, history. And we have a lot of other investigations that have quietly happened where Congress decides not to proceed with impeachment. It is a time-honored, respected practice. Edmund Randolph, a member of the Virginia delegation, made very clear during the Constitutional Convention debates that without the regular process of impeachment, the alternative would be tumults and insurrections. We have revolutionaries, turned statesmen, founding a new country, determined to make that country stable. And their biggest desire was to have a way to control a president that they're giving tremendous power. Madison, for example, in debates in the first Congress involving the creation of the State Department, for example, talked about impeachment. He talked about presidential liability and impeachment for the wanton firing of a meritorious officer. If the president doesn't abide by his oath of office to faithfully execute the laws of the United States and to preserve, protect, and defend the Constitution, Madison said he should be impeached. And he gave examples. And one of them was the wanton firing of a man whose merit justifies his retention in office. One signer of the Declaration of Independence, who also signed the Constitution, who also served on the Supreme Court, was a Pennsylvania law professor. Lived very long, one of the longest living founding fathers. His name was James Wilson. And Wilson taught, having signed every important document. He's one of only 6 people who signed both the Declaration and the Constitution. And I know of none of those guys other than Wilson, who also served as a U.S. Supreme Court Justice. When he was a law professor, he taught that the president is liable in impeachment for his negligence in selection, retention, and failing to supervise the folks in the executive branch. It's what we lawyers call vicarious liability. It's a principal-agent relationship, but it's also a relationship that we see in everyday workforce. When you have a CEO of a company who does not do the proper job in his high officers, when he appoints officials who are corrupt, when he pushes his own conflicted of interest children, when he engages in practices, the Founding Fathers were adamant that this could not be accepted. Gouverneur Morris, who wrote the preamble to the Constitution, We the People, Gouverneur Morris was a very famous constitutional delegate. He also had a mouth on him, and George Washington tried to kind of control that. But he was a brilliant, brilliant writer. And Gouverneur Morris was initially against impeachment. But during the constitutional debates, he confessed that he had been persuaded that we must have impeachment to rid ourselves of a president who is corrupt. And the example he gave was betrayal of trust to a foreign country, or having a president who is in effect in the pay of a foreign power. The examples from the Constitutional Convention and these brilliant revolutionaries turned statesmen were amazing to me. I'd not learned any of this in school, and it doesn't jump out at you when you read the Constitution, which says you must prove a high crime and misdemeanor. The people who've written some of the best work on this are people like Chief Justice William O. Rehnquist and the Cato Institute and some of the people who prosecuted President Clinton, such as then Representative Lindsey Graham, have some of the most apt things to say about the true purpose of impeachment. And so I ended up writing hundreds of pages and having an indexed document that a lawyer could use as grounds to and ways to plead a case of impeachment. And that didn't go over well with the publisher, but they recognized something in it, and they said, rewrite it and make it accessible. And we did, and it got published. And so since then, I've been traveling around the country. I'll tell you where it sells best. It's Washington, D.C. This has really become a passion of mine to educate people so that when you're debating somebody or when you're on the street talking to normal people, and it's not just ardent Democrats who are up in arms over what's happened to our country. There are people of good conscience who recognize there's a problem, and they do not realize that there is a solution which is not revolutionary. It is not conceptually hard to understand once it's explained to you, but there is this absence of information that is as simple as, if the president is convicted of a crime, debatable whether it can happen or has to be delayed, but if he is convicted of a crime, and that's where we should go, everybody's arguing, he still is president. You can't remove him from office, and he can pardon himself. It's unconstitutional, it's illegal, and he has the power to do it, and the solution is impeachment, because there is no criminal statute that says there are no criminal laws about the president. Impeachment is the initial solution. Now, if the pardon amounts to obstruction of justice, you sure as heck can prosecute him later for what he's done, for intimidating witnesses, for protecting others, for making sure that nothing happens because he's pardoned and sent dog whistles to other people. But to save the country, the Founding Fathers were adamant that what you do is you impeach. And Madison wrote, and this was at the Virginia Ratifying Convention. This is the last thing I'll say, and I'll open up for questions. At the Virginia Ratifying Convention, Madison and Mason staged a debate. Okay, it was a real debate, but you know, they were driving over on their horses to the Virginia Ratifying Convention. They were probably talking about how they were going to explain what the massive powers of the presidents were. And so Mason says, to try to explain and teach the Virginia delegates to vote for the Constitution, Mason says, I'm worried that the president might self-pardon. And Madison answers, I'm telling you, they had a drink the night before, set the whole thing up. And I don't know that for sure, but you can just see them. They didn't get along, but here they are debating. And Madison replies that if the president does so, or if he in any ways shelters suspicious persons who would be acting on his behalf, the remedies shall be, the House shall impeach, and the Senate will convict him if he's guilty of the offense. There is no doubt that self-pardon, in and of itself, is a single example, one act that will get a president impeached, if you want to talk to the Founding Fathers who wrote the thing. There is There's not one question. And yet you don't see any discussion about this. For some reason, we've all been told, because the Republicans have said this, you know, if you talk about impeachment, our complete nutty right-wing pro-Trumpers are going to come out in force. So all of you Democrats, don't talk about impeachment, because we'll win if you do. I'm not sure that we should all be guided by what the Republican pundits are starting to tell us. And so it is my position, and you can tell, I'm all for initiating impeachment discussions now. And I predict that if we don't, and if we don't hold the people who are running accountable, Democrats and Republicans across the country, if we do not hold the federal candidates who are running responsible now, that after the election, they will get elected officialitis, and they will not respond as efficiently and as promptly as they should. Because right now, there is more than sufficient evidence to impeach. I promise you, there are so many single acts in and of themselves that are impeachable. There is no other case in the history of the United States of impeachment like it. With that, why don't I open it up to questions so you can... Yes, sir.
Do I need the mic, or should I just...
I'll repeat it.
Okay. Now, granted, I'm not going to argue that, say, firing James Comey would be, you know, the wanton termination of
okay.
Whatever the phrase is.
One can argue whether Comey's firing was wanton.
My question is, where exactly do you draw the line beyond just, you know, a president exercising his right to terminate people that he hasn't appointed? Because the first case of impeachment came against Andrew Johnson, and it was for violating the Tenure of Office Act. Okay,
the question is about why can't the president make his own policy decisions using the example of Andrew Johnson, which is an excellent example. Congress had passed a law that said, basically, Johnson, you can't appoint your own cabinet, and you are stuck with Lincoln's cabinet. And therefore you can do nothing and your hands are tied. And Congress said, very angry that Lincoln wasn't there and instead they had the other party, the vice president who ascended. And so they were very angry. And so they tried to impeach Johnson for haranguing, and haranguing's not impeachable, and for doing something principled in terms of deciding who should be his advisors and cabinet members. And that resulted in an acquittal of Johnson, the right result by all accounts. The difference is, we are talking about the importance of a president who is not acting within his policy-making function or within his normal functions. We're talking about substantial harm caused by the acts. I have to keep emphasizing, impeachment goes to punish harmful, to prevent, not punish, harmful conduct. And the harmful is the important word. The president could do something very stupid, but if it caused no harm, and by that I mean caused no harm to our system of justice, caused no harm to the way we interpret the Constitution, or didn't harm anybody, he should not be impeached for it, because the Founding Fathers didn't want mere maladministration, and they certainly didn't want policy decisions or personal preferences of the president to be hamstrung. What Johnson did was not a wanton firing. He was well within his rights. And by the way, he was vindicated decades later under the Taft administration when they passed a similar act and rescinded the Tenure of Office Act. So that's not at all what I'm saying. You have to plead and prove that the conduct was harmful. Let me give you an example. President Clinton was impeached. There was enough evidence to show that he'd comported himself and had perjured himself. But the real question for conviction and impeachment is, did he harm anybody? Was there, and it can't be just any harm, it has to be substantial harm to our system of government, to our society, or to the country. There was no evidence that any such harm had occurred. And the House, who prosecutes the case, they're called managers, House managers. The House managers failed miserably in the Senate to prove any harm at all. President Clinton was acquitted. President Nixon never was impeached because he saw the handwriting on the wall. President Nixon had committed heinous crimes. He was an unindicted co-conspirator. You guys probably remember those days in the 70s. And we didn't even learn it all till afterwards, the extent of what creep was doing, the absolute subversion of the rule of law. And we thought, at least I did, I was in college at the time, I thought, we're never going to have a president this unlawful. We're never going to have anybody who disregards the rule of law so blatantly. And so disregarding the rule of law, for example, saying, I could pardon myself if I want, which Nixon didn't even try to say. He asked questions, he found out he couldn't, and so he didn't try. There's a huge difference between what happened with President Johnson and what happened with, what will happen, and I'm hoping, with President Trump. And if you...
Shut that door.
It's going to be your birthday.
That's better.
Any other questions? Yes, ma'am.
Would you explain the rule of law? I mean,
What is the rule of law? What is the rule of law? In England and in many of the monarchies from the 19th century on back, we had what I think most historians would call rule of men, where the individual was the country in the case of England. The King of England owned the country in fee simple. He literally owned the entire country. He was the kingdom, and therefore whatever the king wanted is what he got. And the philosophers and the very well-read men who established the United States, and they were very smart. They were geniuses. They'd read a lot of different ways. They even studied, you know, the ancient Greeks, for example. And they decided that they wanted an entirely different method whereby no man would decide what the law should be. And one wonderful example is treason in England was defined after the fact, after someone had committed or done something, and the king would be allowed, and the king minions and officers would be allowed to say, well, you've committed treason, because there was no rule of law that said, here are the definitive characteristics of treason. And then you could do it ex post facto, after the fact, just make up whatever the law was. And the king was allowed to do it, and his people were allowed to do it, because there was no rule that the law is what applies. A man made the decision. So that's as basic as it is. And when you have one man who says, I have the absolute pardon power to myself, using those exact words, I have the absolute power to self-pardon, that's somebody who's saying, I have the rule of man. He's completely beyond the rule of law.
I feel that's very interesting that you mentioned that impeachment is based on a harm that a president that would do, but would that extend to economic harm? Because he's done that on the micro and macro level.
The question is, would harm include economic harm? And the answer to that is, it really depends. If it's ordinary policy disputes and they cause economic harm, the answer is no. Impeachment only lies for extraordinary harm, life-threatening harm. And I don't mean it life-threatening, but the harms that occur by incompetence and negligence need to be answerable. And what the Founding Fathers emphasized was, not every negligent act would be impeachable. Not every crime, by the way, is impeachable. Lots of crimes are not impeachable. And when you do have one of them committing a crime, an officer, you have to prove the underlying harm anyway. You cannot impeach someone for committing a crime. It's been tried, where they tried to say, in an article of impeachment, you committed a crime, therefore we can impeach you. The Senate properly did not vote yes on that article of impeachment. Instead, they voted yes on the impeachment that said, you took money as a judge to do something wrong, and here's what you did. So corruption is a huge category of impeachment, one that the Founding Fathers defined. Madison said that what he worried most about was incapacity of a president somebody who couldn't act properly, or a corrupt president. He said either of those, he predicted someday would be fatal to the republic. Incapacitated president or one who was corrupt. And we have corruption over and over and over again. Yes?
Is that the key? Is that what you think or believe, that corruption might be the road to impeachment?
Question, is corruption the road? Is that the key? Is that the road? It's going to depend, because what you need is it's a political process. So in the House, you have to get a majority of the House members to vote yes on at least one article of impeachment. The Judiciary Committee ordinarily drafts the process. They draft the articles. And sometimes it goes to Rules Committee if it's not really ready even for Judiciary. And only the House can decide. It's in their sole power. You know, the word sole only appears twice in the Constitution, S-O-L-E. Once for the House's sole power to impeach, and the other for the Senate's sole power to try the case. It's not appealable to the Supreme Court. So, if you want to know where I stand, I'm fixing to publish in Law 360 what's called an omnibus article of impeachment that they've asked me to do. And what I've done is put out the ones that I think are most likely to draw votes from across the aisle on important articles of impeachment. And you can have as many as you want. And you're allowed to repeat, the Congress, you're allowed to repeat, you're allowed to rephrase, you're allowed to replead. You have a lot of flexibility. It all depends on what the House says they want to put in the articles. And then once you're in the Senate acts both as judge and jurors. So you have 100 jurors you're going to need to persuade. And some of them don't always agree with each other. And they horse trade, and they're allowed to horse trade. And each one votes his own conscience. And when we talk about the Johnson impeachment and the famous Republican recusants who crossed over to the Democratic side because they felt so strongly that what was happening to Johnson was wrong. They've ruined their careers, and they are profiles in courage, literally, because those were examples cited by Kennedy in the famous Profiles in Courage of the great Senator Ross, who was reviled for his vote to save the Johnson presidency.
It only lost by one vote.
They voted, yes, sir, and one could argue who was the vote, but there were 7 who crossed over, and it was the dramatic Ross vote, and it was quite an exciting time. And Rehnquist wrote a great book about it, and also about the impeachment of Samuel Chase, Supreme Court Justice, and both those acquittals of people who were persecuted, a Supreme Court Justice impeached, and in his trial in the Senate, which Chase defended himself, and in the Johnson impeachment in the Senate, what Rehnquist wrote, one of the most conservative, justices, Republican appointee by Nixon, what Rehnquist wrote was that those decisions, impeachment decisions, are some of the most important precedent in the history of the country. More important than any single law case decided by a court. The cases decided by the Senate are incredibly important. There are 6 of those. There are 8 impeachment convictions in the history of the United States, and they're all very, very important. And they start with that conviction of a senile judge, showing that the Senate can decide that there is sufficient harm to the country to warrant impeachment.
Yeah, I just wanted, it takes a majority of the House, right?
Yes.
Okay, does it take 2/3 of the Senate?
Yes, exactly. It takes 50% plus one, and in the Senate it requires 2/3 of the Senate.
Okay. Well, I had another question.
Yeah. There's a follow-up. Unlike Sanders, I would like to listen to you and hear what you have to say. Sorry, can you believe? Never mind, we won't go there.
Okay. No, I just wanted to go further with the corruption idea because we're Democrats. Okay, we reason, we think, we look for right and wrong. Okay, I just don't see that happening with, our senators that are not Democratic.
Well, I can
These days,
list.
they seem to be so
The point is here is how will we get some of these
Right.
Republicans over?
Right.
I can't name all of them for you, but there are a number of Republicans who voted to convict Bill Clinton on obstruction of justice. Now, it's not worded as obstruction of justice when you impeach and convict or try to convict. It's called interference with justice, because you don't have to prove intentional obstruction.
Right.
You don't have to. But let's just call it obstruction of justice, because that's the words everybody uses. There are a number of Republicans sitting there right now. And there's Lindsey Graham, who prosecuted Clinton.
But he's a Republican. Clinton was a Democrat. Everything's so tribal.
But it is tribal, and believe me, after the Civil War,
Yeah.
and during Reconstruction, and right after Lincoln's assassination, there were some pretty strong feelings running around. And the strength of those feelings are what Rehnquist emphasizes in his book. And the amazing, I mean, sometimes we despair and we think, has the country ever been like this? 1968, that was really bad. And you think, but think back to the Republicans in Congress coming back in just a foul mood. They lost their president. They have this Democrat in the White House with a wife who is still in Dixie, and everything's a mess, and they're out to get him. And they were sure they'd get him. And you have these 7 Republicans who hold out, and knowing they're ruining their careers, and knowing that they're in physical danger at the time. And Ross, when Ross voted the way he did, people went ape. I mean, they just went crazy. So I have hope, and I believe there will be a lot of pressure applied on those Republicans who voted to impeach Clinton, claiming that his lying about his affair and how he comported himself by saying, I did not have sex with that woman, because lying is impeachable, no question. Deceiving the public is impeachable. But it has to cause harm. And they thought that was sufficient harm, that the president who headed the Department of Justice, when he commits perjury, it is a more significant harm than anything else. Well, do we have any doubt that we have a lying president? So I believe that their pressure could be placed on those, but I believe it's voters, and it's going to be our Republican friends that we're going to have to convince. And if we don't talk about it now and educate Republicans that this is impeachable conduct, then it won't work. But we got to talk about it. And there's I know you've got follow-up, so.
Well, one comment and one question. First of all, a lot of the Republicans in Congress are not falling behind, some of Trump's tweets.
Comment that Republicans in Congress don't follow him.
Everyone but
Trump.
Devin Nunes has called him out on that and said, no, there was no spying going on. So those people could be
talking about Spygate here, saying that he's been called out by Republicans on Spygate.
And secondly, I do listen to progressive radio a lot, and they've actually said that while we tend to say that high crimes and misdemeanors is whatever Congress says it is, there is actually a working definition in English law of, specifically relating to abusing the power of office.
Okay, and the question here is that there is much talk that there is a definition of high crimes and misdemeanors. And yes, under English law, if a lord committed something that was abusive, somebody who was of the nobility did something that was abusive, he could be impeached, and the penalty, if convicted, was off with his head. Commoners who were tried in the House of Commons could be impeached, but it was much more rare, very oddly used, and they could be penalized with anything short of death. So we gained some knowledge, and the founding fathers were very well versed. Many of them were English law trained. They were all English lawyers, the ones who were lawyers, because that's where you learned law. Many of them studied at the Inns of Court in London. A tremendous number of them did. So we have trained lawyers. John Adams tried impeachment cases. And they had books. We know that Jefferson had a beautiful library with impeachment books. And they read the lectures of the famous Black and some of the famous British law teachers. So they knew what it was. And they debated it, and they modified it. And the way they modified it was they would use it as the concept, but There was no death penalty attached. So they changed high crimes and misdemeanors in that sense.
Well, the penalty, but how much of what is actually meant by?
Well, I go into that a lot in the endnotes in the book, because Woodison and Black gave many definitions. It was not just abuse of power. And you'll see some really thick and long endnotes in the book from Black and mostly from Woodison. Woodison described conflicts of interest as being impeachable under British law. Abuse of power.
But Trump says he can't have.
That's right. And so there's a whole lot to be learned from British law. Some of the real shorthand books, even shorter than my 88 pages, some of the shorthand books say we don't need to know anything about British law, and I strongly disagree. We do need to know a little bit, and that's why there's, you know, a 3 or 4 page chapter. You know, it's a little dense, I will admit, and it's heavily endnoted, but those endnotes are at the end, and you don't have to read them unless you're as nerdy as I am. But there is, you make a good point. British law helps us in defining impeachment, but it is not the be-all and end-all. And we know through the debate between Madison and Mason that they were grabbing a phrase that would substitute for the narrowness of treason. In Britain, the broad treason law is what the king used, along with his advisors, is what the king used to punish his enemies personally. Rule of man, not rule of law. And that broad treason example is what the Founding Fathers refused to countenance in the Constitution. So constitutional treason was very narrowly defined. It would require 2 witnesses testifying in court with personal observation of a confession of treason or the treasonous act. Well, during the Civil War here, we learned what treachery would be pled as. It was pled as a high misdemeanor. There was a federal judge, and this federal judge during the Civil War decided to wage war against the United States while he held from his federal bench. And so he abandoned his federal bench, but he didn't resign, and they were there for life. And so Lincoln couldn't do anything to fill that federal bench because the guy had gone south, and he was seizing, he literally, yes, he was seizing Northerners' land. His name was West Humphreys, and it's a really cool case. And they accused him of high misdemeanors, and he didn't show up, and Congress did very well unopposed in that case. And because they didn't have any witnesses, they didn't have to prove any state of mind. They just proved factually what had happened and the harm it causes the country to have a treacherous federal judge ruling from a southern bench against, he was scooping up Northerners and putting them in jail and acting as if he were a real judge. And he did have his federal credentials. So he was impeached and convicted in absentia. It's not a criminal process. There's no right to confront your witnesses. No particular rights other than the ones Congress gives.
No,
Okay. We're just waving at each other. Over there. Or maybe no, somebody's just waving. Hi. Yes, sir.
Yeah, even if we have a strong blue wave to get the House in November,
Thank you very much.
do you really have hope that we get 67 senators to vote conviction? I think we can impeach him if we can get a blue House. But
I think it depends. I think it depends on whether or not the senators think that their jobs may be in trouble, and that they may be accountable. Or let me just say, if they recognize that their place in history will be that they saved the country from the next Hitler in Governor White's view, and now we're holding innocent children in cages at the border of the United States, asylum seeker parents who have every not only international right but national right to certain constitutional protections of due process under long-standing precedent. We are caging children under conditions that we don't know how bad they are. We have killed 5,000 people in Puerto Rico after the fact by virtue of delayed services. that were given to citizens of the United States who were treated as less than citizens. We have a president who calls people from various countries animals. We have racial animus, and so we have a situation unprecedented. It's not like the Johnson case. It's not like any of the 19 impeachment cases or even the investigations that have happened in history of the United States. This one is so far off the books, and when some folks spoke out against Spygate, or when Paul Ryan spoke out today on Spygate and said he's wrong, the president is wrong, and you are having some Republican, I'll call them recusants, they're realizing they may need to cross over. And yes, there's a lot of corruption going around and a lot of strong feelings, but to answer your question, yes, I do believe. The stuff I've read about the power of impeachment, will it take a war that's caused? I don't know, but I think that this issue on the border, which is clearly illegal, we've created, the UN has condemned the United States for violating the rights of children. I think this one might explode for him. It should have been when he claimed the absolute right of self-pardon. Yeah. Yes, ma'am.
One thing, I think I've heard that they may be waiting until after the election because the mayor had a chance that they can impeach him. And also,
What about waiting till after the election for a better chance?
But the other thing that was really upset me when I heard that they're raiding like 7-Eleven stores, looking for people. The
raids of small stores, just affirmatively seeking out people who are undocumented.
That's what the Nazis did, you know.
That's what the Nazis did, yes.
It upset me when I heard that.
Very upsetting. And I think that it's the totality of these things. They're starting to crest so that people are realizing this isn't just some power-mad, nutty guy who's willing to do anything and has tremendous financial conflicts of interest in violation of all sorts of laws and the Constitution. But this is somebody who would do anything. He represents the existential threat to the country. And it's the existential threat that once the Republicans are willing to acknowledge it, and I think they're beginning to acknowledge it in this last week, because according to some folks, I've spoken to some folks at the ACLU, the horror stories that are going to come out about what's happening to these people who are being separated from their children, some of them lasting months, and the illicit nature of the conduct. The embrace of white supremacism, apparently, it isn't shocking anyone. And it's amazing that we have the president speaking to CIS, an avowed white supremacist hate group, and having appointed as the Assistant Secretary of State a person who was a member of CIS. It is unthinkable. It's almost as unthinkable as the president saying that football players are not allowed to express their First Amendment rights. Period. They're not allowed to do it. And to disinvite a person of color, black people, to the White House, built by slaves, how the dastardly nature of that and the regression that it causes for us. We could be in the times of Johnson. We could be in Reconstruction, which was one of the most horrible times. The murders, the massacres, the refusal of the South to acknowledge upon the death of Lincoln, thinking that they could actually revert to the